Señoras,
Ladies and gentlemen, please rise. We have the President of the Inter-American Court, Judge Nancy Hernandez Lopez, entering the court, and the General Registrar of the Court, Pablo Saavedra Alessandri.
muy buenos días.
Good morning. The Inter-American Court of Human Rights welcomes the members of the Diplomatic Corps, and special greetings to representatives of the countries which requested the advisory opinion, Chile and Colombia, who are joining us in this act. We also wish to welcome the Special Rapporteur of the Inter-American Commission on Human Rights on Economic, Social, Cultural, and Environmental Rights, representatives of international organizations, civil society organizations, academic institutions, and those following us through our institution's social media. We are gathered today for the solemn act to notify Advisory Opinion number 32 of 2025 on the climate emergency and human rights, requested by the Republic of Colombia and the Republic of Chile. This advisory opinion represents a substantial contribution of this tribunal to the progressive development of international human rights law, considering the challenges we have in our world today with climate change. Before formally commencing the act, we invite you to watch this video on the submission of advisory opinions.
En enero de 2023, los gobiernos de Chile y Colombia presentaron ante la Corte Interamericana de Derechos Humanos una solicitud de opinión consultiva preguntando cómo responder a la emergencia climática con un enfoque de derechos humanos. Así comenzó el proceso consultivo con mayor participación en la historia del tribunal. Se recibieron más de 260 observaciones escritas presentadas por alrededor de 600 actores, incluyendo estados, órganos internacionales, instituciones nacionales, representantes de la academia y la ciencia, organizaciones de la sociedad civil y personas defensoras de los derechos humanos. Para escuchar y conocer de cerca las preocupaciones y propuestas de las personas, la Corte viajó a lugares marcados por los efectos de la crisis climática. Barbados, referente del Caribe, recibió a la Corte y fue sede de la primera audiencia del 23 al 25 de abril de 2024. Allí, 60 delegaciones integradas por profesionales de la ciencia, activistas, juristas, personas de distintas generaciones de América, así como de Europa, Asia y África, alzaron su voz en un llamado común. La segunda audiencia se celebró en Brasil, del 24 al 29 de mayo de 2024, donde 116 delegaciones llegaron de diferentes lugares que se extienden desde Alaska hasta la Patagonia. En Brasilia, la niñez habló con determinación. Las infancias sienten ecoansiedad ante el contexto histórico actual e instaron a abrigarse con ecoesperanza. En Manaos, corazón de la Amazonía, fueron protagonistas los pueblos indígenas y tribales, quienes compartieron la profunda relación entre sus vidas y la crisis ambiental. Después de un largo proceso, la Corte Interamericana de Derechos Humanos presenta la Opinión Consultiva 32 de 2025, dirigida a establecer el alcance de las obligaciones de los Estados para proteger los derechos humanos en el contexto de la emergencia climática.
A continuación,
We now have the registrar of the court referring to the procedure that was carried out in this process. Good morning. On January 9th, 2023, the Republic of Chile and the Republic of Colombia submitted a request for advisory opinion on the obligations of states to respond to the climate emergency in the context of international human rights law, on the basis of Article 64.1 of the American Convention and pursuant to Articles 70.1 and 70.2 of the Rules of Procedure of the Court. The Secretariat of the Court conveyed the request to member states of the OAS and other competent bodies of the organization. Likewise, we invited interested parties and organizations to submit written observations before the deadline of December 18, 2023. Later, the Secretariat received 263 briefs from 613 different stakeholders, including states, OAS bodies, international organizations, state institutions, communities, non-government organizations, academic institutions, people from the civil society, indigenous communities, businesses, and children. Upon completion of the written procedure, the President of the Court convened 3 public hearings, as we saw in the video. The first was held in Bridgetown, Barbados, on the 23rd, 24th, and 25th of April 2024. The second in Brasilia on the 24th of May, and the third in Manaus on the days 27, 28, and 29 of May 2024. During the hearings, 185 delegations appeared before the court. As was stated, we highlight that this was the advisory opinion with the highest participation in the history of this court. In the process, the composition of the Inter-American Court of Human Rights was comprised of Judge Nancy Hernandez Lopez, President of the Court, Judge Rodrigo Mudrovich, Vice President, Judges Humberto Sierra Porto, Eduardo Ferrer Magregor, and Ricardo Perez Manrique, as well as female judges Veronica Gomez and Patricia Perez Goldberg. The court deliberated on the advisory opinion during its sessions in February, March, April, and May of this year. The advisory opinion was adopted on the 29th of May of this year. The text was drafted in Spanish and it covers 7 chapters which address the request, the procedure, jurisdiction, admissibility, preliminary considerations, the analysis of the climate emergency, determining the obligations of states in the context of the climate emergency, and resolution items. We will now hear from the President of the Court, who shall refer to the content of this decision and the most important points. Thank you. Thank you, Registrar, and good morning to everyone who is joining us and hearing us. I will now list some of the main contents of the Advisory Opinion number 32, 2025 on climate emergency and human rights, highlighting 10 of its main points, as the opinion has about 300 pages in length. The first issue that was covered is that the court declared its jurisdiction to pronounce itself on the request according to the American Convention and the Rules of Procedure. To adequately perform its consultative role, it reformulated the questions by the states covering the following topics. First, the obligations from substantial rights derived from these rights, such as the right to a healthy environment, to life, health, personal integrity, family and private life, private property, and others, considering the impacts or threats created or worsened by the climate emergency. 2, the obligations derived of procedural rights, such as access to information, the right to participation, and access to justice, considering the impacts created or worsened in the context of the climate emergency. And 3, the necessary measures to ensure that there's no discrimination, to ensure the rights of children, environmental defenders, women, indigenous peoples, Afro-descendant and farmer communities, and other population groups that are in a situation of vulnerability in the context of the climate emergency. Second, the court highlighted that the interpretation in the consultative opinion, in the advisory opinion, has to be considered extensively and holistically by all the member states of the OAS. This is because the provisions of the American Convention and the Protocol of San Salvador and the consultation are closely related to other binding instruments to all member states of the Organization of American States, particularly the charter of this organization, the Inter-American Democratic Charter, the American Declaration on the Rights and Duties of Man. Likewise, in order to establish the relevant facts to substantiate its legal analysis, the court considered the reports of the IPCC, as these are the best source available for scientific guidance regarding climate change, considering the representative and methodological and rigorous of the states. Third, the court had a factual and analysis of the causes, consequences, and risks for the effective exercise of rights regarding people and territories in the most vulnerable positions in the Americas, such as the Amazon region and the island states and territories of the Caribbean. The court highlighted the impact of climate change on global temperatures, oceans, the cryosphere, biodiversity, health, life, food and water security and safety, and the cultural heritage of humanity. It analyzed the international progress and the regional progress, including treaties, legal decisions, standards, and regulations domestically of all the member states of the OAS and other relevant sources of international law. I also wish to highlight that the court concluded, based on the best available science, that the current situation is actually a climate emergency. And this is because of the accelerated increase of global temperatures, which are produced by different anthropogenic activities that are created in an unequal manner by the states of the international community. These affect incrementally and seriously threaten humanity, and most especially the most vulnerable people. It also highlighted that the climate emergency can only be addressed adequately through urgent action and effective measures to mitigate, adapt, and progress towards sustainable development, coordinated with a human rights perspective and always with a view to resilience. In the definition established by the court, the climate emergency is characterized by the interaction and joining together of three factors: the urgency of effective action, the seriousness of the impacts, and the complexity of the responses required, highlighting the need to have effective action to mitigate and adapt to avoid the risks derived from this climate emergency. Fourth, on the general obligations of human rights considering the climate emergency, the court established three obligations: the obligation to respect, the obligation to ensure, and the obligation to cooperate. And for the obligation to respect, the states, as the court found, must refrain from any type of behavior that leads to less accelerated change of measures considering the impacts of climate change. Any drawbacks and any stalling of climate policies and environmental policies must be duly justified based on objective criteria and follow the standards of necessity and proportionality. As to the obligation to guarantee or ensure, states must adopt all the necessary measures to decrease the risks derived by the degradation of the global climate system and through the exposure and vulnerability of these effects. The court also highlighted, as per its jurisprudence, that the obligation to ensure and consequently the obligation to prevent require action of enforced due diligence in the context of the climate emergency. Enhanced due diligence requires the following aspects. First, to identify and evaluate in a comprehensive, detailed, and profound manner all the risks. 2. The adoption of preventive measures that are proactive and ambitious to avoid worse climate scenarios. 3rd, to use the best available science to design and implement climate action. 4th, the integration of a human rights perspective in the creation, implementation, and monitoring of all policies and measures relating to climate change in order to ensure that these will not lead to new vulnerabilities or worsen existing ones. 5. Constant monitoring of the effects and impacts of the measures taken. 6. The transparency and accountability constantly regarding the acts of states in climate matters. 7. Regulation and supervision, adequate regulation and supervision of business due diligence. 8. International cooperation reinforced, especially in terms of technology transfer, funding, and capacity building. Likewise, the resolution sets forth that states must cooperate in good faith, progressing towards the respect, guarantee, and progressive development of human rights that are threatened or affected by the climate emergency. The obligation to cooperate must be interpreted in light of the principles of equity and common but differentiated responsibilities. The court also highlighted that states have the obligations to cooperate in good faith to advance towards the respect, guarantee, and progressive development of human rights that may be threatened or affected by the climate emergency, considering their differentiated responsibilities, considering the causes of climate change, their corresponding capacities, economic and technically speaking, and their specific needs to achieve sustainable development. States must effectively cooperate and also receive cooperation, because of this is that this depends on the integrated response to cover the multiple causes and effects of the climate emergency. The court also highlighted that considering the protection of human rights in the climate emergency, it's not just referred to mitigation, adaptation, or covering losses and damages. The obligation to cooperate covers all the necessary measures to respond comprehensively to this emergency. 5th, substantial rights, so those rights that are particularly vulnerable to the degradation of the environment and consequently the impacts of the climate emergency. In that sense, the court found on the right to enjoy a healthy environment based on its jurisprudence and established its position more specifically in the protection of nature as a subject of rights. And it pronounced itself on the jus cogens obligation of not creating irreversible damage to climate and the environment. It referred to the obligation to protect the climate system as well as having a healthy environment and climate, and it developed obligations derived from the right to a healthy environment in the context of the climate emergency. As to the recognition of nature as a subject of rights, the court found that ecosystems are complex, interdependent systems where each component has an essential role for stability and continuity of the whole. Degradation or alteration of these elements may produce negative effects that cascade, as the court found, that may affect other species and human beings in their quality of being a part of these systems. In recognizing the right of nature to maintain its essential ecological processes contributes to the consolidation of a development model that is truly sustainable, respecting the planet's limits and guaranteeing the availability of vital resources for present and future generations. Based on this understanding, the court highlighted that states should not just refrain from acting in a way to cause significant environmental damage, but they have the positive obligation of adopting measures to guarantee protection, restoration, and regeneration of ecosystems. These measures must be compatible with the best available science and recognizing the value of traditional, local, and indigenous knowledge. Likewise, the court pronounced itself on the nature of jus cogens of the imperative prohibition to generate massive and irreversible damage to the environment. In this sense, and the majority of the judges found, based on the best available science, the breaking of the balance of our common ecosystem progressively modifies the conditions for the healthy living of species in the planet that are interdependent to each other, to the point that it leads to existential proportion damage. Therefore, the legal responses must be universal and effective. Considering that the balance of the conditions for a healthy life in an ecosystem is a requirement for the livable of the present and future of the planet, the legal protection is a necessary prerequisite, considering the protection of legal goods already covered by international law, including those covering prohibition of conduct that do not admit any agreement otherwise. Looking at the irreversible impact of anthropogenic activities would undermine the necessary conditions for fundamental rights of human people that are already protected by international law as standards of that superior hierarchy. Therefore, the obligation to preserve the balance and the equilibrium must be interpreted as an international duty and an imperative one. The court concluded that the principle of effectiveness, added to considerations of dependencies, necessity, universality of the underlying values, and the non-contradiction to current law, is the legal substantiation to recognize the imperative prohibition to generate irreversible and massive damage to the environment, and it contributes to the compliance of obligations already acknowledged by international law. Therefore, in considering the nature of the jus cogens standards, the court mostly considered that all states have to cooperate to put an end to any conducts that violate prohibitions derived from imperative standards of international law protecting a healthy environment. Additionally, the court recognized the existence of the human right to a healthy climate. This recognition responds to the need of providing the inter-American legal order with a basis to clearly delimit the state's obligations considering climate crisis and demanding compliance autonomously regarding other duties linked to environmental protection. The court understands that as a healthy climate is one that it can be derived by a climate system that has no anthropogenic interferences that may be dangerous to human beings and nature as a whole. This means that we must recognize in functional conditions and even in the absence of these interferences that climate is variable and that this variability entails inherent risks that may affect the security and safety of ecosystems. The court stated that the right to a healthy climate has individual and collective connotations. In its individual sphere, it protects the possibility of every person to develop themselves in a climate system that is free from dangerous anthropogenic interferences. In the collective sphere, it protects the collective interests of present and future generations of human beings and other species to maintain a climate system that is adequate to ensure their well-being and the balance among the species, considering the serious existential threats derived from the effects of the climate emergency. As per the principle of intergenerational equality, states must actively help through environmental policies current generations, ensuring stability conditions in the environment to allow future generations similar development opportunities. This principle is closely related to the principles of prevention, precaution, and progressiveness. In that sense, states must ensure an equitable distribution of the burden derived from climate action and the impacts of the climate, considering their contribution to the causes of climate change and their corresponding capacities. This distribution must avoid the imposition of disproportionate burdens, both for those who will be part of our future generations and for those who are in the current generations. The court also highlighted that the obligations derived from the right to a healthy climate have the purpose of protecting the global climate system to the benefit of humanity as a whole, of which the present and future generations are part. This court considers that this aspect acquires particular relevance in the context of the climate emergency, considering that the impacts of climate change are progressive, they intensify over time, and they tend to fall on specific groups more strongly. So climate change will affect people that are very young today more than those living today at another age, and they will have an adverse climate environment. The right to a healthy climate also projects its efficacy on nature, considered the physical and biological foundation of life. The protection of the global climate system requires safeguarding the integrity of ecosystems of living and non-living components that are part of it and sustain it. The preservation of climate conditions compatible to life is essential to maintain the balance and functionality of ecosystems. This mutual interdependence between the climate stability and ecological equilibrium and balance reinforces the need for an integrative legal approach in order to articulate the protection of human rights and the rights of nature within a consistent framework with the harmonious interpretation of the principles of pro persona and pro natura. And for this we must have a systemic, integrative, comprehensive perspective that must be strengthened significantly when we recognize nature as a subject of rights. In that sense, the court observes that the legal conceptions and mechanisms to protect promoted by states at a national and international level that go beyond a traditional anthropocentric or human-centered approach and recognize nature as one of its components as a subject to autonomous legal protection reinforces and strengthens the response of states considered in the context of the climate emergency. Sixth, in this context of the climate emergency, the right to a healthy environment and climate, we can derive specific obligations related to the causes of climate change and especially the mitigation of GHG emissions. On this particular point, the court found that states have the obligation to regulate, supervise, and monitor, as well as demand and approve environmental impact studies. The obligation to regulate in terms of mitigation entails different duties to states, particularly defining a mitigation goal or target, defining and maintaining a strategy that is based on human rights to achieve it, and regulating the behavior of companies and enterprises. Mitigation targets must be established thinking about the principles of progressiveness, common but differentiated responsibilities, equality, prevention, and precaution. In defining their targets, states must consider the best available science, their current contribution and historical contribution accumulated to climate change, the capacity to contribute to mitigation targets, and the circumstances in which they are in. The mitigation target must be as ambitious as possible, included in a binding standard and regulation for the state with specific deadlines for its compliance and progressively increased. Additionally, states must define a mitigation strategy that is based on human rights. In this sense, they must ensure appropriate measures with real possibilities of being enforced, considering the sectors where the main GHG emissions are created in the state, the costs associated to their reduction, and the benefits this might have in preserving the global climate system. Regulating the behavior of companies, adopting measures to supervise and monitor this, and determining the climate impact of projects and activities when necessary. Seventh, the court found that states have the obligation to protect other human rights through measures that avoid or reduce impacts as much as possible under the enhanced due diligence standard. For such effects, the court first analyzed the nature and characteristics of the general measures that must be adopted, and later referred to the specific measures regarding the rights to life, personal integrity, health, private property, housing, the freedom of residence and circulation, water, food, work, social security, culture, and education. It highlighted one of the shared obligations to all rights, which is the essential character of the measures for climate adaptation to protect human rights. States have the obligation to define, as the court held, and update their national climate adaptation plan. These plans must be designed to ensure they reach the adaptation targets and goals for each state, and having the necessary measures to prevent and decrease the impacts of climate change on human-generated activities as far as possible with enhanced due diligence. The court underlined that these measures must be appropriate to reduce vulnerability and increase resilience of people, communities, and ecosystems, considering the effects of climate change. These plans must be based on the best available science and must be designed in a way to minimize any negative secondary effects derived from the adaptation measures. The court also highlighted that, considering the principle of precaution, states must refrain from developing or authorizing any adaptation strategies that may affect the integrity of ecosystems without a prior environmental impact assessment to ensure their feasibility. Considering the principle of progressiveness, the court found that states must guarantee that their plans and targets for climate adaptation are progressively more ambitious. It also referred to the specific duties by the states under the standards of enhanced due diligence to protect the different substantive rights, considering the concrete risks each of them faces in the context of the climate emergency. Eighth, under the second question of the advisory opinion, the court found that to face the climate emergency, states must reinforce the democratic rule of law and ensure the full exercise of procedural rights, so the rights whose exercise is the basis of a better formulation of environmental policies. These include the right to science and the recognition of local, traditional, and indigenous knowledge, access to information and participation, access to justice, and defending human rights. As for the content of each of these rights in the context of the climate emergency, the court decided that the right to science includes access of all people to the benefits of scientific and technological progress, as well as the opportunities to contribute to scientific activities with no discrimination. This also extends to local, traditional, and indigenous knowledge. These knowledges have a special relevance in the context of climate emergency because, considering the urgency and complexity of the measures that must be taken to face it, it's necessary for decisions to be adopted based on the best available knowledge. The right to access to information is, as the court has found, an essential condition for the protection of, among others, of the rights to life, integrity, health, the environment, and a healthy environment and climate. This information allows participation in public administration through social control, and it fosters transparency of state activities, promoting responsibility of public officials over their duties and jobs. States have obligations in terms of production and dissemination of relevant information for the protection of human rights, considering climate change, as well as to adopt measures against disinformation that are fully compatible with the principle of freedom of expression. States must guarantee processes that ensure significant participation in decision-making and in policies regarding climate change, as well as prior informed consultation with indigenous and tribal peoples when necessary. The right to public participation is one of the fundamental pillars of procedural rights. Through it, people exercise democratic control on state actions, and they may question, consider, and reflect upon compliance of public functions. The court also found that participation allows people to be part of the process of decision-making and to demand responsibilities and accountability from authorities. It also found that states must ensure central aspects in terms of access to justice, considering the climate emergency, such as providing sufficient means for the administration of justice, applying the principle pro actione, the celerity and reasonable timeframes of legal procedures, applying adequate provisions in terms of legitimization, evidence and reparations, as well as applying and enforcing inter-American standards. It also found that states have a special duty to protect people who are defending the environment or environmental defenders, which means there should be specific action, including, among others, establishing or reinforcing national programs for the protection, investigating and, when necessary, punishing any attacks, threats, or intimidations environmental defenders may suffer, and counteract the criminalization of the defense of the environment. Ninth, it also highlighted that climate change leads to extraordinary risks, and these affect more seriously the human rights of certain population groups whose situation of vulnerability is increased by the confluence of intersectional factors and structural discrimination factors. These factors include poverty and inequality. The most poor and unequal regions are the most vulnerable to experience the most serious consequences of climate change, as they have less resources and capacities to face such consequences. It also found that by virtue of the principle of equality and the prohibition of discrimination, states must refrain from adopting measures or incurring in any omissions that may directly or indirectly restrict, affect, or limit effective access in conditions of equality to the enjoyment of human rights by people affected by the climate emergency. It also held that they must adopt measures to address the way in which the climate emergency worsens inequalities and has a differentiated impact on people that are living in a multidimensional poverty. And lastly, the court found that the inclusion of differentiated measures in all actions taken by the states is necessary to ensure real equality in the enjoyment of rights in the context of the climate emergency. Although these measures must be defined based on the particular risks that each state has found, the court also held that the existence of certain situations of vulnerability are commonly faced, such as, for example, children and young people or teenagers, indigenous, tribal people, Afro-descendant communities and farmer communities, and population groups such as women, people with disabilities, the elderly population who may suffer disproportionate effects in the context of climate disasters. Vulnerability is worsened particularly when these people are in a situation of multidimensional poverty, which amplifies their exposure to risks and reduces even more any possibilities they may have to overcome the adverse consequences of climate change. The principle of equality and prohibition of discrimination entails the existence of specific obligations for the states. Finally, the court highlighted that in the context of the climate emergency, this vulnerability must be understood as a dynamic and contextual condition determined by the diversity and complexity of the impacts associated to climate change. Therefore, it calls the attention to the need to recognize new forms of vulnerability and adopting specific, reasonable, differentiated measures to prevent and reduce climate risks, mitigate its effects, and facilitate processes that are sustainable in terms of adaptation. I wish to inform that this advisory opinion had partially dissident votes by the following judges, Humberto Sierra Porto, Patricia Perez Goldberg, and myself, judges Rodrigo Mudrovich, Eduardo Ferrer Magregor, Ricardo Perez Manriquez, and Veronica Gomez issued concurrent opinions. Before concluding, I wish to highlight the hard work and commitment by all the staff at the court to face this titanic challenge. I also wish to thank everyone for their patience, their care, their kindness, and their commitment. And thank you to the states of Chile and Colombia for bringing up this very important matter for life on our planet at a key moment for humanity. And finally, I wish to highlight that we often have hopes that others will do something for us in terms of our responsibility towards the planet, but the evidence we have seen and analyzed in the hearings and all the written submissions have shown that there's no space to wait. Finally, this is a contribution from law, but the success, of course, depends on what each of us can do. Thank you very much for your attention. Mr. Registrar, you can conclude this act of notification. Thank you very much, Madam President. I hereby certify that the advisory opinion number 32 of 2025 has been officially notified. Before concluding, we want to inform and share with you that the court is making available to everyone a micro website in terms of transparency, where you might find the advisory opinion and all the written interventions classified by states, sorted out by states, universities, civil society organizations, individuals, and others. You may also find videos of all the hearings with all the interventions of the participants in the advisory and consultative process. You will also find the advisory opinion issued by the court. This is done in the spirit of transparency. We wish to make available all the information that was compiled in these 2 or more than 2 years of the consultative process. It is made available to all of the community. Lastly, we wish to inform that this text is being currently sent out to all the participants of the consultative process, and it will be available from this point on in the court's website and in that microsite that we've just shown. Translations to English and Portuguese of this advisory opinion will be available starting on Friday next week. And the individual opinions that the President has previously mentioned will also be incorporated into the microsite, and we will notify the parties at the time. With that, we now conclude this notification act. Thank you very much. Please stand.